Paschal Donohoe, 20 minutes.
Thank you, Cahirlock, and I welcome the opportunity to address Dáil Éireann on the withdrawal of the United Kingdom from the European Union Bill of 2019, and in particular the elements of the bill which I have proposed as Minister for Finance. In relation to Brexit, the Government continues to hold firmly to the view that the only way to ensure an orderly withdrawal of the United Kingdom from the European Union is to ratify the withdrawal agreement, as endorsed by the European Council and agreed with the British Government. So the Government remains focused on the ratification of the withdrawal agreement and the negotiation of an ambitious and comprehensive future EU-UK partnership. However, we must also be prepared for the possibility that the UK leaves the EU without an agreement. We're doing all we can to avoid this happening, but we need to be ready in case it does. The withdrawal of the United Kingdom from the European Union Bill of 2019 follows on from the Government Contingency Action Plan published in December of 2018, and the measure has been undertaken at EU level via the European Commission's Contingency Action Plan. The purpose of the Government's bill is to protect our citizens and our economy by putting in place the necessary measures to mitigate against some of the worst disruptions and discontinuities which would arise as a result of a no-deal Brexit. As Minister for Finance, my objective is to protect the economic and financial interests of the state and to support the work of the Revenue Commissioners so as to minimise the Brexit disruption to trade to the greatest extent possible. My department is working within the whole-of-government approach and coordinating closely with our agencies, including the Central Bank and the NTMA, who are also heavily involved in developing and implementing plans and measures to protect our economy to the greatest way possible. As I've outlined previously, Brexit, in whatever form, is a historic challenge. And as we approach this challenge, we need to continue to be clear that membership of the Single Market and Customs Union is a core element of our economic strategy and will not change. Ireland will remain an active and enthusiastic member of the EU, and the Government is committed to working with the European Commission to ensure the closest possible relationship between the EU and the UK and to protect the interests of businesses and citizens as much as possible. The legislative amendments which I've proposed in the areas of taxation and financial services will form an important part of this contingency planning. So I'll turn to each in turn. Part 6 of the bill provides for the modification of income tax, corporation tax, capital tax and stamp duty legislation in order to ensure continuity for businesses and citizens in relation to their current access to certain taxation measures, including release and allowances. The part also makes provision for the introduction of postponed accounting for VAT on imports from third countries, an important measure to mitigate the cash flow burden on businesses should the UK leave the EU without a withdrawal agreement. It also provides for the retention of certain capital taxes and VAT anti-avoidance provisions. There are 7 chapters in this part of the bill. The proposed amendments to income tax are covered in Chapter 2, Sections 16 to 41, where various sections of the Taxes Consolidation Act of 1997 will be amended to ensure that income tax measures continue to apply to existing beneficiaries should the UK leave the EU without an agreement. The relevant legislative provisions will, as far as practicable, be extended to include the UK in order to maintain the status quo in the immediate future. The measures covered are diverse and include the artist exemption, the exemptions from income tax of hepatitis and HIV compensation payments and foster care arising in the UK, the application of the seafarer allowance and the fisher tax credit to Irish taxpayers on UK registered vessels, ensuring continuity of relief for SMEs benefiting from the Employment and Investment Incentive, start-up refunds for entrepreneurs, the KEEP programme and the preservation of existing pension release. The retirement arrangements for professional sports persons to ensure that those Irish tax-paying sportsmen and women who retire to the UK can avail of the relief, and the continuation of various reliefs in respect of charitable donations and charities' incomes. The proposed amendments to corporation tax are covered in Chapter 3, Sections 42 to 47. Broadly, they seek to maintain the status quo for the tax treatment of certain transactions or corporate group structures in the immediate aftermath of a UK exit. The purpose of the amendments is to minimise disruption to the greatest extent possible. So the amendments proposed in Section 42 in relation to charges and income for corporation tax purposes will ensure that certain interest payments made by companies to recognise banks, stock exchange members and discount houses carrying on business in the UK will continue to qualify for the relief. Similarly, the amendments proposed at Sections 45, 46 and 47 aim to retain release for certain start-up companies and for companies engaged in research and development activities and for gains realised on certain transfers of chargeable assets owned by UK companies. The proposed amendments to capital taxes are covered as part of Chapter 2, Section 41, Chapter 4, Sections 48 and 49, and then Chapter 7, Section 60. These amendments are proposed in order to allow for the continuity of existing provisions. In the main, capital gains tax and capital acquisitions tax, covering investment and farming release, as well as amendments to cover specific capital gains tax anti-avoidance measures. VAT is covered off in Chapter 5, Sections 50 to 53. The main change being proposed in Section 51 is to provide for the introduction of postponed accounting for VAT. This is a significant measure to alleviate VAT burdens on businesses as a result of Brexit. The change allows businesses to account for VAT on imports in their bi-monthly VAT return, instead of having to pay VAT at the point of importation, which normally applies to imports from third countries. This mirrors the existing VAT system for trade from the UK and will avoid the cash flow burden for businesses trading with the UK of having to pay VAT up front, and also the administrative burden of operating new systems. The amendments proposed at Section 51 are an anti-avoidance measure. Finally, in relation to stamp duties, Chapter 6 sets out the proposed amendments to the Stamp Duties Consolidation Act of 1999, which are covered in Sections 54 to 59. The aim of these amendments is to maintain the status quo. The amendments proposed in Sections 54 to 57 provide for the continuation of stamp duty reliefs on the acquisition of stocks and marketable securities, the reconstructions or amalgamation of companies and the demutualisation of insurance companies. The amendments proposed at Sections 58 and 59 provide for a continuation of stamp duty reliefs on certain life insurance and non-life insurance premia. Today, the Government also approved 2 amendments to be included in the bill relating to duty-free sales and the operation of the VAT retail export scheme between Ireland and the UK post-Brexit. Part 7 in settlement finality. Turning now to Part 7 of the bill, where legislative amendments are proposed to extend the protections contained in the Settlement Finality Directive to Irish users of UK-based settlement systems for trading in financial instruments once the UK becomes a third country. This legislation is related to Irish markets' resilience on CREST, which is the Central Securities Depository based in the UK to settle trades in Irish-listed financial instruments. This legislation is, as I said, related to our resilience in this area. A Central Securities Depository is a settlement system that holds financial instruments such as shares on behalf of investors and facilitates transfers and ownership through electronic book entry rather than the actual physical transfer of paper certificates. It's a key component in financial market infrastructure that enables the safe and efficient trading of financial instruments. In the event of a no-deal Brexit, the European Commission has already adopted a temporary and conditional equivalence decision for UK-based CSDs under the CSDR for a period of 2 years. This will allow the Irish market to continue settling trades while the transition to Euroclear Bank, a CSD based in Belgium, is complete. The proposed amendments to the settlement finality regulations are required to support implementation of the Commission equivalence decision and allow Irish participants to continue accessing CREST. The Settlement Finality Directive ensures that transfer orders of financial instruments entered into designated settlement systems by market participants are legally binding. It provides legal certainty to market participants that trades will fully settle even if one of the parties attempts to revoke the trade or become insolvent. Recital 7 of the directive grants Member States the discretion to extend the protections of the directive to third country systems. At the time of the directive's transposition into Irish law through SI 642/2010, Ireland did not exercise this discretion, as CREST was based in another member state, the UK. Following their decision to leave the European Union, they now become a third country, and therefore it becomes necessary to implement Recital 7 in Irish law, as I'm proposing to do, in order to ensure that the protections existing under the directive continue to apply to Irish market participants. In relation to the designation of settlement systems, I, in my role as Minister for Finance, will decide on this designation following a recommendation by the Central Bank. The Central Bank is required to conduct an equivalence assessment of the UK's legal system as it relates to settlement finality to ensure it's equivalent to the relevant Irish laws and that the rules of the individual system comply with the requirements set out in Regulation 7. The proposed legislation allows for the withdrawal of a designation if the Central Bank deems that either UK law or the rules of the system no longer comply with the requirements as set out in legislation. The legislation also allows for the temporary designation of settlement systems that are already designed by the Bank of England under settlement finality. The introduction of this legislation will ensure there's no disruption to existing market activity in the event that the UK withdraws from the EU without ratification of the withdrawal agreement. Finally, and in relation to Part 8 of the bill, this part provides for contract continuity in respect of contracts of insurance. If the UK withdraws from the EU without ratification of the withdrawal agreement, it will become a third country from the 30th of March in relation to the EU's regulatory framework for insurance and financial services. UK and Gibraltar insurance undertakings or insurance intermediaries will therefore no longer be able to write new businesses in Ireland and will not have the authority to continue to service contracts which were concluded before Brexit. The servicing of contracts would include activities such as paying out on claims or accepting premium payments. Therefore, certain measures are necessary to protect Irish customers in order to ensure the continuity of these services post-Brexit. The Central Bank have indicated that a significant majority of insurance undertakings have proposed appropriate contingency plans which have already been implemented or will be implemented. In addition, most of the larger insurance intermediaries are taking the necessary action to resolve this issue. However, there is a real concern that some smaller UK or Gibraltar insurance undertakings and intermediaries, which do admittedly represent a very small portion of the overall market, won't have implemented contingency plans, or because they do not propose continuing to operate in the Irish market post-Brexit. This part therefore caters for these situations and ensures that Irish policymakers who hold existing life and non-life insurance policies with insurance undertakings or through insurance intermediaries operating in Ireland from the UK or Gibraltar won't be affected due to those undertakings or intermediaries losing their right to conduct business in EU member states post-Brexit. To do so, the bill provides for a temporary run-off regime which, subject to a number of conditions, will enable such firms to continue to fulfil contractual obligations to their Irish customers for 3 years after the date of the withdrawal of the UK from the EU. This measure is exclusively in place for existing policies and doesn't allow these firms to issue new policies. This temporary run-off regime is established by amendment to 2 sets of regulations which provide for the regulation of insurance undertakings and insurance intermediaries, namely the EU regulations of 2015 and the EU regulations of 2018. Finally, deputies should note this regime is in line with the principles set out by the European Commission and the European Insurance and Occupational Pensions Authority, in that it doesn't allow for new businesses to be written, it's temporary in nature, and it's in line with the principles set out in the Solvency II directive. These factors have been key considerations for my department and the Central Bank in developing this regime. Indeed, EIOPA, in its recommendations for the insurance sector in light of the UK withdrawing from the European Union, published on the 19th of February, have effectively endorsed this approach. I am confident, therefore, that these measures should ensure that Irish policyholders are protected in the event of a no-deal Brexit. Ceann Comhairle and members of the House, I hope this gives you a good outline of the many issues that are covered off by the Department of Finance in this bill. The breadth of the issues goes from sports people to settlement systems, which indicates the complexity of this bill and the complexity of the undertaking that lies ahead. But the passage of this bill is vital to ensure that in the event of a disorderly Brexit, we have done all we can to protect the interests of our state and citizens.
Thank you very much, Minister Donohoe.